of 5 minutes, and let me just tell you that we all have read the files, the pleadings, the submission of the records, transcripts, so we are fully briefed on the cases, so if you're ready to proceed, you may.
May it please the court. My name is Luke Perau. I'm here representing James R. Smith and Nan Shen Smith in an action that we have filed seeking review and reversal of the denial of an amended motion to dismiss, a motion for statement of particulars in a case before the trial court in a felony proceeding in Hillsborough County. I think we've laid this out, and as you said, you've reviewed the briefs. The critical aspect of what we're arguing is that the nature of the statute with which these individuals are charged makes the individuals that we are seeking the identities to be disclosed material witnesses. In fact, they're critical to the nature of the charge. Obviously, we've quoted the statute 79605. It's unlawful for any person with reasonable belief or knowledge that another person is engaged in prostitution to live or derive support or maintenance in whole or part from what is believed to be the earnings or proceeds of such person's prostitution. So the designation of another person, the proceeds of income from such person, makes those individuals material witnesses.
That the state has to prove at the trial of this charge.
Well, they would have to prove that.
Break it down. Give me the specific elements.
The elements would necessitate proving that the defendants in this case knew or had reason to believe that another person was engaged in prostitution and that they derived income or maintenance from the proceeds of that prostitution from such other person.
And so help me understand why the specific identity of, and we know that there were at least several from the statements and so forth that are in the record. Why is the specific identity of the individuals who were engaged in prostitution material to the proof of those elements?
It's critical because, as you can see from what we included in the record below, the individuals, and there were 3 individuals identified out of the multiple what we call the predicate counts that were laid out in the information. There were 3, all 3 of them denied ever providing any proceeds to these defendants for any prostitution. In the depositions that were taken of the individuals, and I think if you familiarized yourself with the way the investigation was done, gentlemen would leave these locations, they'd be pulled over for some minor traffic infraction, multiple cars would pull up and you know, they would end up saying, yes, I was at that facility. In the depositions, none of those individuals could remember what the name of the facility was, where it was. So to get beyond that.
The way, just going back to the elements, right? The way that the state has sort of cataloged the evidence for purposes of the charge is by location and time frame.
Correct.
And they've got that laid out in the information and there's some level of detail by each of the locations of massage parlors.
Correct.
Isn't that going to be proof sufficient? And if it isn't, a jury would so conclude, and which leads me to the ultimate question here, and you acknowledge this in your findings. Why isn't this remediable on direct appeal? How do we exercise certiorari jurisdiction here?
Well, the problem is without getting that access to those material witnesses, it would almost necessitate an appeal, but the case law and certainly the constitutional arguments that we've raised require that upon demand, we need to know the cause and nature of the allegations.
Well, let's go back to what the state has to prove, because that's really where this rubber is going to go.
Right.
If the state's case unfolds the way that the 3 witnesses testify, that's a pretty good case for you, isn't it?
We don't know. Because of the 3 people that we've known, you have to remember that there are, I think, 10 different allegations in the information with 10 different locations or thereabouts, and that all it gives us is a date and a street address.
You're never going to get a witness list in this?
I'm sorry?
You're never going to get a witness list at some point in this?
We haven't yet, and we asked for it. I mean, that was the whole nature of what we're supposed to receive.
Well, but the whole nature of what you're here for now, though, is it's not a motion to dismiss, and you're here on certiorari.
Correct.
So, kind of dovetailing with what Judge Brewer was just talking about, has any court ever held that the failure to specifically identify a prostitute in violation of the statute is a necessary element of the information such that dismissal is appropriate?
That's the unique nature of this case. There is no other reported decision that goes to this because
And that's kind of the follow-up, kind of where the shoe falls, which is you're here on certiorari, you're asking us to hold something for the first time, and ordinarily we can't do that in a certiorari context because it has to be a clearly established principle of law that was violated.
Well,
So help me through that.
I think if you just put together the basis of the constitutional argument we make, upon demand, you are supposed to be given the nature and cause of the accusation. Then you look specifically to the statute from which the charge emanated, that it's another person and that you derive proceeds from such person. So I think the constitutional requirement is that that information be given to provide an adequate defense. All of the state's cases deal with lesser issues. None of those go directly to the material witness. They're items of evidence, perhaps a confidential informant. You don't need a confidential informant all the time to prove the elements of the case, unlike this statute where you actually do.
But there's a vein of case law, I'm not sure if the state brought this up, but ordinarily, constitutional questions cannot be decided in an initial matter in certiorari proceeding. So in other words, the argument needs to be made, fleshed out, brought, just discreetly argued, and then brought before the tribunal to decide as an initial matter about what the Constitution requires or doesn't require, and then it comes for the appellate review. But here, you're basically asking us to take the first pass at that, right?
Well, all we're asking you to do is to look at the plain language of the statute. So the constitutional argument, we're not asking you to construe the Constitution. We're just asking you to embrace the plain language of the statute and exactly what those elements are to conclude that these individuals would have to be material witnesses. They would have to be. And the other issue here, and I think something that you certainly have the ability to determine, is that absent those individuals being identified, then these defendants would be subject to double jeopardy. At this point in the information...
Wait. I read the record, the trial judge talked about double jeopardy, and went through the briefs the second time. I didn't find a double jeopardy argument. Did I miss something?
All we have from the information is the date, some ranging from 6 months to 5 years, and the street address. So assume, if you will, that 5 individuals come to testify against these defendants in trial, and then thereafter other individuals come forward or something else. Just because you've got the date and the street address doesn't preclude other individuals who may not be called, who may not even be known at this point in time. I don't think that a determination, even in a trial, of the way that the information is framed would prevent anyone from coming back and present.
You're not really answering my question. Did you brief double jeopardy in this court?
Did we mentioned it, we certainly mentioned it. I don't think we briefed it extensively, but we simply articulated that based on the way that the information is framed, without the identification of these specific individuals, other individuals that fell within that time frame at that address could easily come forward and subject these defendants to double jeopardy. That was what we summarized as the argument.
I'm having a little trouble following that part of it, because to me, the statute requires proof that a person with knowledge is deriving support or maintenance from what is believed to be the earnings of another person's prostitution. And so the operative proof, to me, and I think the trial judge saw it this way, would be permissively derived from the locations and the timeframes. And either the state can make their case with that or they can't. But right now, based on the 3 prostitutes, the state's, that would be a tough sell to a jury, or at least it would be a jury question. So I'm having trouble, you referred us to the definition of prostitute in the parallel part of the statute that's not pertinent here. But that definition is not in this part of the statute. And the statute doesn't require, the way that the straight prostitution charge does require, the identification of the person engaged in the services. So help me out with that.
Well, I think it gets back to the language here, another person. Would there not be the requirement that that other person be identified so that the conduct of that other person could serve as the predicate to meet the elements of the charge that's identified in the statute? If that answers your question. You know, that if there's some statute that requires proof of an element that someone else did something and that you derived income from some other person's conduct, it would certainly seem to be material who that other person is and what conduct they engaged in, when they engaged in it, and how that conduct led to income or whatever benefit.
The conduct is really on the part of the person who's deriving support, isn't it? Isn't that what the statute is focused on? Is the knowledge and intent of the person who's deriving? The defendants here, not the prostitutes themselves.
I don't think it stops there though, and that's the problem. And that's vague, that's indefinite, and that just looks at the frame of mind of the defendant or the operator without any proof of another person.
And so let's get back to part of what Judge Lucas is asking about and really the bases for our search warrant jurisdiction here. I need to better understand, independent of the constitutional arguments, why this is a violation of a clearly established principle of law that can't be remedied, the harm from which can't be remedied on direct appeal.
Well, I think what we refer to and the arguments that we made is that this is different than the cases relied on by the state. There's no reason that the denial of the access to a material witness should predicate an appeal. You cannot prepare for pretrial and then go to trial and then have to raise those issues on appeal when you haven't had a fair opportunity to.
As Judge Lucas asked you originally, where are you in terms of trial date? You say you've asked for this, but we're in the posture of reviewing a denial of motion to dismiss, not a violation or something.
I understand the question. I don't want it to appear that we were premature. The nature of the motion to dismiss and the motion for statement of particulars requested this information. That was the reason that we brought this certiorari before this court, because that was the vehicle we used. We're going through discovery. We want to be able to keep up with the schedule that's been imposed on us by the trial court. We want to do our job the best we can. So please give us this information so that we can continue to go through the discovery process to find out who is that other person. What did that other person do, and how was any kind of monetary income from the conduct of that other person provided to the defendant? Those seem to us to be the material elements of the statute. So trying to find out their identities seem to be our responsibility to defend our clients to the best of our ability. So if you have no other questions, I think that the gist of what we've argued is very clear. I'd like to reserve the rest of my time for rebuttal.
All right, sir. Thank you. You have 5 minutes.
Thank you.
Good morning.
Good morning, Your Honors. Jonathan Hurley with the Office of the Attorney General, represent the respondent in this case. Your Honors, this petition should be dismissed because this court's without jurisdiction to even consider granting the extraordinary writ of certiorari. Binding precedent from the Florida Supreme Court is clear. This court must first analyze the jurisdictional requirement of irreparable harm. Petitioner must show he has no adequate legal remedy on direct appeal. And for that matter, the remedy might actually take place pre-trial, and that actually filing a motion to compel discovery. I mean, that hasn't even been done. Okay? This was a motion to dismiss, challenging, it was a C4 motion. In addition, it was a vagueness, they tied in a vagueness argument and a double jeopardy argument. And then in addition to that same motion, filing, it was a motion for a statement of particulars. The state filed the traverse, they filed the demurrer. There was a hearing on the motion. They reviewed the law. Both parties argued the law. The state notes that the information and the language in the information tracked the language of the statute. The petitioner cites no cases holding that a cert review may be had of a trial court's order denying a criminal defendant a motion to dismiss an information and/or a statement of particulars. The state cited cases that do. Any delay or expense of the accused resulting from a second trial is not the type of harm certiorari exists to prevent. The state's response was perfunctory because the law is clear. You have to address the jurisdiction element first. That has not been addressed. That's why this court can't even consider the merits, the essential arguments of the law argument. If there's no further questions.
Well, I have one question.
Yes.
Your opponent's case, one view of it is that he is relying on some of the principles articulated in Judge Kelsey's dissent. And
Dissent.
Dissent, and I understand dissent,
Okay.
but address the concerns that he raises that are tied to Judge Kelsey's
There
dissent.
appeared to be two considerations in that case. One was what I just touched on, that the Kelsey complained about, oh, this is going to, so much of a burden on we're going to have to retry this case, yada, yada, yada. The law is clear. That's not a irreparable harm that certiorari is envisioned to correct. That's number one. The second concern was in the context of irreparable harm and the ability to prepare a defense. The remedy is clear. If there's a conviction, file a direct appeal, have the case reversed, and the appellate court can simply state, please, you're going to allow pretrial discovery of X, Y, and Z, or whatever you're claiming materially harmed your client in the preparation of his defense. That's the remedy. I don't know why the court, why the judge dissented, but obviously the majority in that case understood what cert review jurisdiction is. If there are no further questions, Your Honor. Thank you.
I think here's the most important issue here. The language in the information does not track the language of the statute. That's the big problem. And I think that absent that, and regardless of what any other issue might be, to urge you that you don't have the jurisdiction to evaluate these arguments, you certainly have the jurisdiction to look at what we've argued under Rule 3.140, that the information itself is vague, indistinct, and indefinite. The information doesn't say anything but dates and a street location. The statute talks about such person, other person. So for anyone to argue that the information tracks the statute, that information would have to be in there. There's nothing that makes it anything less than vague, indistinct, and indefinite.
I appreciate your argument, but what I see is a challenge to the legal sufficiency of the information wrapped in a discovery dispute. Here's why. You all know you challenge the legal sufficiency of the information on direct appeal. There's no cert for challenging the legal sufficiency of an information. It just doesn't exist. It's not out there. So we can't say that she, departed from the essential requirements of the law. You can't get the names at this point. It's early on. We can't reach down and give you an advisory opinion. Oh, you should do this, state. I know the Morris case named the prostitute. Well, that's how the state attorney's office does it over there. But if they don't do it over here, it could be to their peril. But we can't reach down and get involved in that. We just can't.
Well, we certainly brought the appeal in good faith. We felt that it was a departure from the essential requirements of law, and that at this point in time, the decision that precluded us from getting that information on these material witnesses amounted to material harm. So I see the writing on the wall, and I appreciate the privilege, and I hope we don't have to see you again on this case, but I'm very grateful for your time and attention this morning. Thank you.
Have a nice day.
Thank you.
All right. Our next quoting. Fletcher.